Slaying Sunna, Abu Ishaq al-Shatibi's concept of Bida in Al-Iʻtiṣām, McGill University, 1999, Montreal, Canada, A.S. Jahar, Chapter 3. From the examples cited above, Shatibi comes to a conclusion which has certain ramifications for his legal theory. For him, maslaha, as practiced by his forefathers, including the companions, has two facets. Firstly, its conformity with the ends of the Shari'iyah does not fundamentally contradict its roots, or its indicants, dalil, dalail. Second, public interest deals with matters rationally understandable and touching specifically upon customs. This is because customs are unlike ibadah, which are transcendent and incapable of rationalization. Examples being, according to Shatibi, ablution, which is washing oneself before prayer, and pilgrimage. To distinguish the fundamental basis of worship which are beyond human reason and of customs which are accessible to human reason, Shatibi positions himself in the tradition of the Mu'tazila in claiming that reason has no place in the domain of worship. This is because ibadah, like ablution for example, which is irrational, are taken for granted as submission to God, he insists. Cleaning oneself after menstruation, for example, is equivalent to submission, ta'abbud. Therefore, ijtihad has no business in trying to understand any hidden meanings in ibadah. On the contrary, the objections of customs are clear: to preserve benefits, masalih, and avoid harms, mafasid, whereas those of worship matters are unclear. In other words, Shatibi insists that ibadah, being certain and perfect, needs neither addition nor subtraction, while customs are rational and may be modified according to necessity or need. Derivations in the performance of worship which are alien or not attested to by the Shari'iyah indicant are counted as real bid'ah, and therefore are to be absolutely rejected. Masalih mursala, public interests, therefore amount to protecting the constraints of necessary and averting difficulty in religion. In stating this, Shatibi contends that a certain element, probably maslaha mursala, should be included in a relevant case, if its inclusion might otherwise lead to imperfection. This theory, known as ma la yatimmu al-wajib illa bihi, that which is not completed, that which cannot be completed, that wajib which cannot be completed without this thing, apologies, no Arabic translation given, is an indispensable facet of the means of pursuing the end, the maqasid, rather than constituting innovation. The philosophical basis of this outlook is intended to avert hardship. Shatibi agrees that there is a suitability inherent in the maqasid, constituted of necessity, need, and improvement, which function as a kind of human attempt at understanding the Shari'iyah. The suitability of these ends is unequivocal, in line with the roots of universality, usul al-kulliyah, which ensure that the benefits in this world and in the hereafter will not transgress these limits. Such constraints and limitations, Shatibi insists, are not only described in the Quran but also elaborated in the Sunnah. This foundation ensures that as long as there is a textual evidence in the Quran and the Sunnah, applicable legal rulings should always be taken as the basis of an argument, not reason alone. If a certain textual basis of the Shari'iyah is silent, then the employment of masalih mursala is acceptable as long as it conforms to the ends of the Shari'iyah and their indicants. This position shows that the superiority of Shari'iyah to reason helps to protect the community from adjudication of matters leading to bid'ah. This rationale leads to the conclusion that innovation itself emerges through rational assumptions drawn from matters for which the precedent of evidence is lacking. Judging by the moderate position taken by Shatibi, we could say that he was not himself reluctant to use aql, reason, as the basis for legal decisions. He nevertheless tried to place himself at an intermediate position between Shari'iyah, immutable by virtue of the certitude of divine law, and reason, aql, and Naql, Shari'iyah, and reason, aql, which tends towards relativity. Elsewhere he ascertains that reason is inferior to the Shari'iyah, since the latter is universally certain. He repeatedly states that good and bad in the Shari'iyah cannot be decided solely on the basis of reason, since justification on the basis of reason that something is good or bad is relative while the Shari'iyah is certain. As Fazl ar-Rahman noted, Shatibi was convinced that human knowledge based on reason and experience cannot be trusted at all, and therefore cannot lead to action. Put differently, Shatibi accepted rational judgment if based on universal truths, or on a multitude of probable instances of particular statements, juz'iyat, particular statements, and kulliyat, universal truths. Apologies, no Arabic given. One example of this is the theory of maslaha mursala, which is fundamentally rational, though based on this theory of the ends of the law. Wa'il Halak notes that he even went beyond his predecessors in developing a legal theory of induction, by remaining faithful at the same time to the established theory of tawatur, multiple narrations, as the basis of his general theory. He nevertheless exercised caution by rejecting arbitrarily rational judgments, which can ultimately lead to innovation, bid'ah. His efforts may be described as an attempt to reconcile the two extremes represented by the Shar'iyya and reason, though he gave preference to the former. Shāṭibī acknowledged that the Shari'iyya does not elaborate on all rulings in detail, but gives universal guidance in many cases. Therefore, it is left to the mujtahid to use his reason in the exercise of ijtihad. Furthermore, Shāṭibī believed that the validity of maslaha mursala and istihsan, for instance, as source of law, is unequivocal, though neither is explicitly referred to in the Quran and the Sunna. However, their compatibility with the universal roots, usul al-kulliyya, is obvious, in that they both benefit human beings in allowing them to perform God's ordinances. Accordingly, the role of reason in the aforementioned process is indispensable. Shāṭibī, however, insists that adjudicating good and bad in worship is the prerogative of the Shar'iyya, whereas in mundane affairs, where logic plays a greater role, reason may be favoured. Having viewed the legal principles held by Shāṭibī, we will look into what follows at the different arguments of other scholars which lean one way or the other in the context between Shar'iyya and reason. Our account will show that Shāṭibī is certainly more objective in the sense that his middle way reflects a more reasonable balance between the rational and the scriptural camps. Stay tuned for many more parts.